All right. Are we ready?
Yes.
I think we're ready.
Okay. The court's on the record in M1945736, the state of Texas versus Charles Edward Harris. We are here on the court's notification of defendant's failure to comply with interlock order dated April 16th, 2020. Will counsel please announce?
Yes, Your Honor. Thomas Wynn here on behalf of David Finn for Mr. Charles Harris.
Let the record reflect that Charles Harris is present by video teleconference. Mr. Harris, can you hear me?
Yes, Your Honor.
Okay. Mr. Harris, we're here because you were released on bond for the offense of driving while intoxicated second, and that as part of your conditions of bond, you are required to have an ignition interlock or home monitoring device. And according to this notification, you are in violation of your conditions of bond by not regularly providing breath tests on your device. There were 62 breath tests provided to the interlock device from February 26th to March 26th. May I hear from counsel as to why we were not in compliance during that period?
Judge, well, first and foremost, I don't think that my client nor Mr. Finn were ever notified of the minimum number of starts that needed to be ascertained here. I think after this violation came out, Mr. Harris was informed that he needed to have 3 starts a day. After talking to multiple different interlock companies, this seems to be a fluctuating number where we don't have an actual set number for each month. Clients aren't always informed, and they're not always informed timely, especially. In this particular case, it appears that Mr. Harris's occupation at the Milkshake Concepts, working there, he was essentially furloughed due to COVID-19, and that really started effective officially on March the 16th. As we all know, everyone was having kind of conflicts with that before that time period, but since March the 16th, he's been really unable to go into work, has had no need to go into work due to the closure, and so he's been at home. He has not been operating the motor vehicle, and that is, in our opinion, the reason for the decreased number of starts. He does have 62 starts in that time period, which we think is significant enough to show that he has no actual violations. He has not been consuming alcohol, and we would argue that this is not a true violation, and that we will work hard to make sure that we do 3 starts a day so we're not back here in front of you on this same issue.
Okay. Mr. Wynn, do you have any notes regarding the interlock violation hearing that was held with Mr. Harris on December the 4th, 2019?
I do not have any notes from that hearing. I do understand that I have notes here from Smart Star saying that, I guess, on December the 17th, that was when his system was installed, here from the Smart Start. But I do not have any notifications of any violations before that time period.
Okay. So, we had a hearing on an interlock violation where Mr. Finn appeared with your client, and he was told that there would be 0 tolerance with regard to any violations regarding his interlock, and he would receive a jail sanction if we had to have this conversation again. And so what I'm going to do today, because I don't want to put anybody in jail because of low blows, because they haven't had enough blows, but the fact of the matter is, not blowing according to the instructions is a violation, just like any other violation. The reason why people don't blow a lot of times is because they have been drinking. That's the whole point. And so you blow, you're supposed to blow. You blow 63 times. Why not just blow the requisite number of times? It doesn't make a lot of sense to me. And then the whole point is that we're trying to monitor people that are out on pretrial release to be sure that they are not consuming alcohol, not just not driving, but not consuming alcohol while they're on bond. So in order for us to do that, then your client has to blow the 3 times per day.
Judge, is that known to anyone though? Because that wasn't known to us.
Well,
I've heard sometimes I hear 40 times a week. I've heard 50 times a week. I've never seen someone blow 62 times in a month and be violated for low blows.
Well, let me tell you that 90% of the people that have interlock on their vehicle or have any type of device have to blow a minimum of 3 times a day. Right? So you're going to have in a 30-day period at least 90 blows, right?
I'm not good at
And
math.
so, yeah, me neither. It's the whole law school thing. But let me say this: I'm gonna hold the defendant accountable for getting all the information that they need. That's why they have orientation. They're giving this information, and when you come back and tell me that you didn't get it, that doesn't help us because your accountability doesn't change. So, but what I'm going to do is I'm going to notate today that Mr. Harris needs to make sure he is in contact with Ms. Bro in pretrial services to confirm his requirements, and that after today there will be no tolerance for any misunderstanding. That as far as we're all concerned today on this record, that he is not to consume any alcohol during pretrial. That means no cough suppressant, no mouthwash with alcohol. If he gets a prescription that for medication that contains alcohol, he needs to alert pretrial services in the court and, of course, his attorney so that we can address that issue. So I'm just going to admonish him today. I'm not going to do this whole jail sanction thing that I said I was going to do before because of your advocacy on his behalf.
Thank you, Judge. And we promise that we will get back and we'll make sure that we do 3 times a day. And I know you're understanding here, and I appreciate that. It's difficult times right now. I know some people are going, weeks without even operating a motor vehicle just because they're not leaving their house. And so I will remind Mr. Harris that he needs to make sure, even if he's not going anywhere, to go out and do a start-stop.
Like a postman, rain, snow, sleet, hail, nor dark of night shall prevent Mr. Harris from completing his appointed rounds with his device. And I need to make sure that we have, when is your next court date, Mr. Wynn, with Mr. Harris?
June 10th, I believe.
Okay. Okay, so on June 10th, that'll be, you'll either pass that for whatever reason. There won't be a court appearance required on that day, will it, Mr. Wynn?
No, Judge, I do not believe so.
Okay, fantastic. Is there anything else you think I need to do, Mr. Wynn, to help your client be successful?
No, I do not, Judge.
Mr. Harris, good luck to you, sir. You're doing
Thank you.
okay. Let's just keep it together until Mr. Finn and Mr. Wynn can get this resolved, all right?
Yes, ma'am.
Everybody be
All right,
safe. I'll talk to you
Thank
soon,
you,
Mr. Wynn.
All right, you should hang on, Judge. I have something for you. Mr. Harris, I'll give you a phone call.